Well, welcome back to our one-on-one conversation series with contributors to the Volume 4 of the Perth International Law Journal. Now, it's my pleasure to be joined today by Dr. Erika Techera. Dr. Erika Techera is a professor at the UWA Law School and the UWA Oceans Institute with a passion for and a wealth of experience in environmental research, including areas such as marine wildlife conservation and fishing regulation. Now, she's had regular involvement in various research centres at UWA and has held key positions within the UWA Law School and the UWA Executive Office. Erika, it's a privilege and a pleasure to have you on.
Thank you very much. It's a pleasure to be here. Thanks for having me.
Great, thanks so much. So your contribution to our journal in this volume is an article entitled Platforms, Plastics and Parasites, International Law Responses to Contemporary Marine Pollution Issues. So how I envision this to go is, we'll chat a bit about some of the concepts you explore in your article, as well as touch on some broader notions to do with international environmental law. And I guess what we'll start with is, first of all, your article revolves around 3 case studies of contemporary marine pollution issues, which you've dubbed Platforms, Plastics and Parasites. Now, can you expand on these and explain what they refer to exactly?
So if I could start with plastics, because that's probably the best known to everybody, that's really exploring the issue of marine debris, marine pollution in the ocean, which is plastics based. Most of us have seen some photographs or images, video of the plastic pollution. And we know that that pollution is not evenly distributed around our oceans in the world. We know that most of that plastic pollution comes from land. It isn't coming directly from the dumping of waste in the ocean itself. And we know that it's not all big bottles or straws or plastic bags. Of course, they are important problems we need to address. But we also have this issue of microplastics, where this plastic pollution breaks down in the ocean and sinks within the water column and will stay there for a very, very long time. These types of plastics are not going to degrade by themselves in any meaningful time frame. And so we really need to address both the ultimate problem, which is the pollution of our ocean, but also the cause of that problem. Parasites, I was really referring to there, biosecurity and the invasive species. So this is another issue that is caused by human activities, in this case shipping and transport. We have little microbes and little shellfish and other mollusks, other animals that adhere to the bottom of vessels that may go from one country to another, and they may become dislodged in another country. So they are alien species, and where they are quite strong or aggressive species, they can become invasive and overtake local species. It's not just on the outside of vessels. Most large merchant shipping vessels carry ballast water, which they suck up water in one harbour location and then they discharge it in another. And we need to be very mindful, again, of introducing species that don't belong in that new environment. And the last one was platforms. And here I was really talking about oil rigs and pipelines and other infrastructure we have in the ocean and what we do when it reaches its end of life. So whilst those oil rigs are all operational, the pipelines are being used, they are out in the ocean for decades at a time. Often microbes, other life forms around that infrastructure. And then around those small species, we might have fish assemblages, we have whole ecosystems that form. At the end of life, what do we do with that infrastructure? Do we take it all out? Do we leave it there? Again, another problem that we have to address because it can become a marine pollution problem in the future.
Absolutely. And I noticed that in a bit of background research as well, there are currently more than 550 rigs in use at the moment, which will be decommissioned in the next 30 years, as I understand it. So that's a lot of infrastructure out there which will just be sitting there, and obviously it's quite bulky structures. It's about what to do with them.
And a particular problem, I think, for Australia, because Australia has a much younger oil and gas industry than other places in the world. So a lot of our infrastructure is just coming to the end of life now or in their coming decade. Whereas if you look at Europe and the US, they have a much older industry where they've already had to deal with this problem of decommissioning or end of life disposal of infrastructure in the ocean.
Right, well, what role does international law have to play in responding to these marine pollution issues which you've raised and addressed?
So international law and international environmental law is very important in addressing a number of environmental issues. principally by setting standards, creating a forum for discussion and sharing of ideas, and achieving global agreement on how to deal with these problems. Particularly important, I think, in the ocean, because the oceans are shared. It's not something where state sovereignty is as easily seen as on terrestrial environmental problems, which occur within the land of any one country. So when we're talking about our oceans, and let's, for example, just think about the plastic pollution issue, we know that there are jars of plastic out in the ocean, and this is often well beyond state waters. So we're talking about the high seas. So international law has a really important role to play in addressing both the problem itself, but also the causes of that problem. And in each of the three areas I chose to write this article about, there is different international law. Some of it's new, some of it's older, and some of it doesn't really even exist yet, and there's a gap that needs to be addressed. And so these three case studies, I think, really sort of exemplified the sort of challenges of some of these contemporary issues and the role that international law can play, already plays, and will need to play in the future.
Well, to follow up on that, what are some of those existing frameworks that currently exist? Could you briefly summarise those, perhaps, and what you believe to be their most significant shortcomings?
Oh, well, I think I'd like to talk about some of their strengths as well as their shortcomings as well. There's plenty of international law here. So the Convention on the Law of the Sea, the UN Convention on the Law of the Sea, is the principal international instrument for oceans. And this is a fundamental instrument which has got very high buy-in by countries throughout the world. It sets those maritime zones. That's how we know we have high seas. We know we have the territorial sea and the exclusive economic zone. And so that's pretty much accepted by all countries in the world. UNCLOS also has an important standard setting role. It creates specific obligations to protect and preserve the marine environment, to conserve and manage living resources, but also to ensure that the non-living resources are protected as well. So UNCLOS really creates a framework. It doesn't necessarily provide all the detail. So, for example, in relation to marine pollution, it talks about encouraging states, either together or alone, to develop regional and other laws to address, for example, land-based marine pollution. And that's the problem really in relation to plastics. In other areas, when we look at oil and gas, if we look at pollution from ships, for example, we've got much more detailed international law that some of it existed before UNCLOS, but also has continued to develop afterwards. And in relation to the parasite issue, we also have the Ballast Water Convention, which has very recently come into force, only in the last decades to come into force, and that it tries to address this ballast water issue. Perhaps beyond UNCLOS, and then we've got between UNCLOS and the Ballast Water Convention, we've got the London Convention and Protocol, which addresses and prohibits the dumping of waste at sea. And we have MARPOL, the Marine Pollution Treaty, and its annexes, which try and address marine pollution from ships, but incidental or operational pollution rather than deliberate dumping. So leaking of oil or rubbish escaping overboard from a vessel. So in terms of some of the issues I've looked at, UNCLOS provides certainly a framework to address decommissioning and infrastructure in the ocean. It creates a framework for marine pollution. Not all the detail for land-based pollution, but we do have these other treaties filling the gaps. And then we've got the parasite issue in the Ballast Water Convention, which is a later convention in relation to that. We also have the Convention on Biological Diversity, which doesn't only apply in the ocean, but seeks to address some of the issues around invasive species. So rather than specifically talking about shipping, ballast water, biofouling, for example, it does address invasive species. So I think there's very well-developed, strong laws in relation to deliberate and incidental dumping of waste from ships. There are certainly more general obligations in relation to land-based marine pollution, in relation to invasive species more broadly. But in recent times, the only sort of new hard law we've seen is the Ballast Water Convention.
So what it sounds like is a combination of prohibitory rules and standards which are to be well, it seems like progressively realised, essentially. Is that, am I getting the gist of that correctly?
Yeah, so I think, you know, there's what we call quite hard law, the pointy end of law in terms of the London Convention saying states shall not or states shall prohibit the dumping of waste in the ocean. I mean, that stands to reason. It doesn't just cover plastics, covers the dumping of any waste in the ocean. And then we see MARPOL about the incidental pollution from ships. That could be, you know, having an accident and an oil spill, but it could also be waste overboard. It can also, the other issue, of course, is things like nets or other plastic polluting materials that might fall off the deck of a ship, which also are important. So UNCLOS creates the broader framework, but really it's only in relation to pollution from ships. We've got that pointy hard law prohibiting or encouraging states to prohibit these activities. The Ballast Water Convention seeks to put in place a system, so saying all ships should have a system on board to treat ballast water, so that when it is discharged, it doesn't have organisms in it that could be dangerous in another environment. So that's a very different type of treaty. It's a sort of technological solution requiring a ballast water management system on board or treatment facilities at a port, which allow water to be discharged through a system and to basically be cleaned of anything that's considered to be invasive. There's some definite gaps though. So we have a gap in relation to land-based marine pollution. We don't have any hard law there saying what countries should do or setting standards or sharing information, transferring technologies, etc. in relation to land-based marine pollution. And we do know that is where the majority of plastics come from. One of the other gaps we have is in relation to the outside hull of ships. So where organisms are attaching to the hull, that's called biofouling. Now we don't actually have a binding treaty in relation to that area. What we do have, the biofouling treaty itself actually addresses the types of paint that you can put on a vessel to prohibit or to inhibit the growth of biofouling or growth of organisms on the outside of a hull. And that's really to do with protecting the ocean from the dangerous substances we might paint on a ship, not protecting it from the biofouling itself. And then in relation to decommissioning, we have an interesting sort of situation where we've got very different approaches around the world. So in that sense, the international law leaves a little bit of a gap. It leaves it to states to decide precisely how decommissioning will be regulated. And this makes perfect sense, I think, because almost all infrastructure in the ocean sits within national waters. It's not a high seas issue in the same way that other aspects of shipping are. So, and we see very different approaches taken in different parts of the world. In the US, very much an encouragement to leave some part of an oil rig or platform or pipeline in place, not necessarily above the surface, but maybe to cut it off and then leave in situ some of that infrastructure for the very simple reason that it has become an artificial reef. Organisms have attached to it, fish have assembled around it, and it's created its own little ecosystem. So America has taken the approach of encouraging in situ decommissioning, whereas the EU prohibits that. You must remove infrastructure at the end of life, and if you want to create an artificial reef, you've got to create that from new materials, not from a recycled or reused old platform or pipeline. And Australia, as I said, is now grappling with this issue, and so too will be the whole of Southeast Asia, which again has a relatively young oil and gas industry and now facing decommissioning. So Australia again leaves the gap open. It favours in situ decommissioning, largely because the contracts that were written back when oil rigs and pipelines were constructed, which was many decades ago, certainly built into that the concept that all infrastructure should be removed at end of life and the ocean floor returned to the way it was before. But of course, it's impossible to turn a natural environment completely back to where it was before. Absolutely. And it's incredibly, not only expensive, but also difficult, technically difficult to remove an oil rig. So when an oil rig is constructed, we use gravity to help sink that to the ocean floor. So you've got to reverse that process, and you're talking about absolutely massive structures. So there are special decommissioning ships which can be used, but it's a very technologically advanced area. It's an area where the marine scientists are telling us, you know, you could actually do more harm than good by trying to take it away. The engineers are telling us you can mostly take some of it away, but in some cases, gravity, it's too hard to overcome gravity and remove some of these structures. But then on the other hand, there is a perception, certainly, that to allow oil and gas infrastructure to stay in place would be, sanctioning pollution for an industry which makes a lot of money and can afford to remove it. So there's no right or wrong answer to that question. That's something NOPSEMA, that's the regulator in Australia, is grappling with at the moment, providing guidelines and seeking submissions, considering those submissions and looking at what the future will hold for decommissioning here.
Well, I guess that makes a good segue to one of the criticisms it's going to raise. That's usually levelled at law, and that is the failure to adequately keep up with the times and the pace of human activity, as we've been talking about. So how is this especially relevant, that law keeps up with times in the field of environmental law? Could this perhaps be attributed to an inadequate level of, or a level which could be improved, of communication between scientists and lawmakers and policymakers, for example?
I think that's certainly one aspect, but I think it's quite a complex area. So we've sort of seen a tendency to distrust science in the last few years. I think this is a very concerning trend. We've certainly seen it in relation to climate change, where everybody has an opinion on climate change, but very few of us are actually qualified to really understand the science. I certainly think science communication, and we can see that at universities, it's now taught as a subject because of this issue of how do scientists communicate not just to their own disciplines, but to law, policymakers, managers, and the general public. So those, I think, are two other aspects. I certainly agree with you that law struggles in many cases to keep pace with technology, science, and innovation. So it is partly a question of keeping pace with it, and partly a question of listening to it. I think also law, a fundamental principle of law is that it has to be certain. So if you have a contract that was written for the construction of an oil rig 4 decades ago, you can't undo that and say, yes, well, the clauses we put in about decommissioning now should be overrun because we've now decided that there's a better way to do it. So there's that sort of very practical aspect, which is something that needs to be overcome. I think also that the pace of change, and I've written another article on this about the pace of innovation and technology and change is so great that law, it could not meaningfully keep up with it. Most laws are reviewed, most national laws in Australia are reviewed every 5 years, yet we're all seeing technological developments that seem to almost emerge on a daily basis in some cases. One key area there is sort of remote sensing technologies, sensing from space. We can send underwater autonomous vehicles out to monitor pipelines, that kind of remote technology. We can now have algorithms, machine learning, and we're all hearing much more about artificial intelligence. What role does it have to play in monitoring our oceans, in helping us determine the extent and the location of, for example, plastics in the ocean? How can it help us explain where that plastic comes from? So that kind of innovation and technological development is so fast that it would just be a challenge for any area to keep up. Policy, politics, law, people. It's very difficult for the public and education to keep up with that as well.
Sure. Well, you suggest at one point in your article that's a modification of an old protocol, the Montreal Protocol, which is on the matter responding to the depletion of the ozone layer, which targeted harmful man-made substances such as chlorofluorocarbons, and adapting it to target the problem of plastic pollution. Now, the Montreal Protocol, being effective from 1987 and a product of the Vienna Convention for the Protection of the Ozone Layer, which itself was signed in 1985, so as I understand it, the most universal ratification for a treaty recognising the impact that humans have on the environment. Now, in your opinion, is it time for another convention that strives to have the same effect and that responds to more modern challenges, perhaps?
So I referred to the Montreal Protocol. It's one example of a suggestion that's been made by several researchers in relation to the phase out of some plastics, for example. There are a couple of other suggestions as well, expanding the Basel Convention, which is about the transport of hazardous waste, particularly there in relation to plastics for disposal and recycling. And then there's treaties like the Rotterdam Convention and the Stockholm Convention, which relate to chemicals, the regulation of chemicals, and should plastic be put in the same category, etc. So there are a few examples to draw from. In relation to your specific question, I think that we have to unpack the issue of marine plastics. It's not the same as as ozone depleting substances. So if we go back to the Montreal Protocol, yes, it had huge buy-in. Law of the Sea has huge buy-in from different countries, but we have to remember that the manufacturers and producers of the ozone depleting substances, there were just a handful of companies in just a couple of countries in the world. So this was really a question of production. How are we going to restrict production? The way in which they did that was to say we're going to substitute substances. So the producers of ozone depleting substances have to swap to new substances which are less ozone depleting. So you have to think about that and say, well, maybe we could use that model for the production of virgin plastics, which is the very, very first, the creation of plastics from petroleum. Maybe we could address part of the problem of marine plastics, for example, by a similar approach. Will we get that buy-in? I think there are certainly many people advocating for that. There are many researchers working on that aspect because, again, there are relatively few producers of those virgin plastics. But I don't think that is the whole answer to the problem. Because if you think about ozone depleting substances, they were in aerosol cans, they were in fridges, and these aren't things that you and I can go and buy in a supermarket. We could buy the aerosol can, but we weren't in control of what substances were within it.
Sure.
So by regulating the actual the substances themselves right back at the production process, the Montreal Protocol was successful. With plastics, we've got that problem of the virgin production, but we've also got the problem of consumption. Should we go back to using glass bottles where we can? Should we still allow plastic bottles? Should we be using material science to create new types of plastics which are less damaging, that biodegrade, for example, that are made from natural products? But that's further down the supply chain. So we have virgin plastics at one end, but turning a virgin plastic into a Coca-Cola bottle, for example, is further down the chain. And then we have the issue of disposal. What we should do in terms of disposing of plastic. What's the best way to dispose of plastic waste so that it doesn't end up in the ocean? And then we also have the issue of recycling. So I think we have a bigger range of challenges that would not easily, I mean, it could be done, but not easily be answered in one single treaty. So the production and consumption and recycling are different aspects, which I think is partly why researchers are looking at something like the transport of hazardous waste, the Basel Convention, more broadly, because that's something about saying, well, we shouldn't collect waste in one country and ship it to another country and make it someone else's problem. So, and we know that is a problem because some of the new research coming out is showing that the plastic that ends up on the beaches of Australia, for example, doesn't come from Australia. It comes from another country. That's oceanography. The ocean currents bring it here, and the plastic that emanates from Australia ends up in New Zealand or another part of the world. So we know that disposal and the recycling issue is another one as well. We have to think innovatively about that because we don't have a land-based marine pollution treaty itself to draw upon. Not just in relation to plastics, in relation to any substances, we don't have that. We don't have an international waste management treaty. There is no treaty that says this is the best practice in the world on how to dispose of domestic, residential, commercial waste. Some countries use landfill, prefer that, some use incineration, etc. So there's a few issues there. I think in some of those areas, to get back to your question, I think there is some potential for international law to play a role. But in so many areas, it will really depend very heavily on the national context. In Australia, for example, we can ban plastic bags. We may be able to ban or restrict the use of plastic water bottles. But in many places in the world, there is no potable water. They do not have access to water drinking water out of a tap. They have sanitation issues. So what are the choices for those countries? And it wouldn't be for a developed nation to tell a developing nation, for example, that they can't have plastic bottles of water when there is no other way to get drinking water. So I think the problem is much, much more complex, and that's why it sort of defies an easy international law solution in the way climate change has kind of defied that solution as well.
That's right, yeah. Still a lot of issues that need to be resolved, I guess, before you can insert them into a universal treaty, for sure. Well, look, we have another article in our journal that argues strongly for soft law in addressing environmental problems. Now, I wonder if we can get your opinions on this concept.
Yeah, so soft law, informal law, is not technically binding on nations. And I'm working a little bit on that at the moment, on a project in relation to informal lawmaking at the moment. Soft law has a very important role to play in international environmental law. It can fill some gaps. I said to you before that the law of the sea, UNCLOS, creates a general obligation to protect and preserve marine environment, but there are some gaps that soft law can fill. It also can, what they call, thicken the law, which is to provide detail of how something might be achieved. And it also can involve more actors. And this is very important in some of the problems I've been looking at, partly because international law by its very nature involves state parties, but of course manufacturers, the private sector, industry, consumers are all important parts of the puzzle that we're talking about here. We're talking about shipping or oil and gas platforms. These are privately owned by corporations. They're not not state-owned infrastructure in many cases. And plastics were all involved in that sort of problem. So I think soft law has a role to play. We have seen quite a lot of soft law. We've seen United Nations Environment with a global program of action on plastics, which is soft law. We've certainly seen the development of hard law from soft law as well. So countries that may be concerned about signing up to a hard law treaty will be more inclined to accept a declaration, for example, United Nations Declaration. We've seen that as well in relation, United Nations General Assembly Declaration in relation to marine plastic pollution. So it can be a stepping stone. We need to be very careful, and this is something that is alluded to in the article written in the journal, which is soft law doesn't have legitimacy in the way hard law does. It is often the process of its creation is not the same as hard law. And it can look like law, but not actually be law. These sort of pseudo norms, I think is the word Alexander uses. So it certainly has a role to play, and we can see that in action, particularly in relation to plastics. But it's not, in my view, the complete answer.
Well, perhaps looking towards the future now and on some future considerations, wondering if you can speak to anything that has come to light, perhaps since you've written your article or out of your any of your current research, and perhaps in the face of such an extraordinary year that points to some kind of developments in this area.
Well, in the three areas, in relation to platforms, we've certainly seen, as I alluded to at the beginning, NOPSEMA in Australia taking a much more interest and more proactive steps in relation to disposal of platforms, driven in part by need in Australia because of the decommissioning issue. In relation to plastics, we can see myriad examples of research, lots of suggestions, both certainly a lot of organisations. CL, the Centre for International Environmental Law, is one that's pushing for a global plastics treaty. We can see a lot of science as well. And I've been working with some researchers on determining where plastic pollution comes from in the ocean, which countries has it come from. And that's interdisciplinary in the sense of saying, well, let's look at the oceanography, let's look at the way the currents move. So lots of developments there, which will inform, I think, anything that is done in relation to marine plastics. It's not going to be a one simple silver bullet there. And in relation to the parasite issue and the invasive species, I think you can see more and more countries implementing the Ballast Water Convention now. It came into force only a few years ago and just starting now to really kick in terms of the kinds of facilities countries have to have and or ships have to have on board their vessels. So I think we're seeing more, I would say, in the way of implementation of initiatives, implementation of existing law obligations, but plastics is probably the area where we're going to see more hard law, I would expect. And we can certainly see that at the national level in relation to plastic bag bans, and even in Western Australia, we've now got an encouragement and incentive to recycle and return plastic bottles. But I think probably one of the most interesting areas for me, and one that I've been involved in only about the last 18 months, is this issue of remote sensing, satellite tracking, autonomous vehicles, the use of artificial intelligence, machine learning algorithms to both collect data of importance in relation to monitoring human activities or monitoring the ocean, and then also to process that data. So increasingly we are seeing a lot more technology being implemented in relation to specific issues. So for example, we know that we can track, for example, oil spills. So you can track vessels. You can, if from satellite, from imagery, you can see an oil spill. You can trace that back to the vessel through not necessarily humans looking through hours and hours and hours of video data, but using machines, artificial intelligence, to do that for us. Remote sensors, we've seen a lot of both drones being used with little sensors on board. Those sensors could be a camera, but it could just be a chemical sensor that can tell them the emission of different chemical indicators on board. And then we've also seen a lot more developments in relation to low Earth orbit satellites, because Australia's now got its space agency. Other countries are looking at these very low Earth orbit cluster satellites, tiny little boxes the size of your toaster, not the high Earth orbit. These are sitting low Earth orbit, and sometimes in clusters, so many satellites which could have various sensors on board. I think this is where we're going to see some developments. Hopefully that will mean, from a legal point of view, hopefully it will mean better monitoring so that we can ensure compliance with the law. So if you know vessels are not supposed to be leaking any oil, the MARPOL Convention says you shouldn't have any operational leakages of these 5 substances, for example, you could have a chemical sensor being able to tell whether you are in fact leaking those substances. We've got new types of cameras, new types of digital imagery, synthetic aperture radar, which isn't a camera type image, it can see through cloud to track vessels. We've got new vessel monitoring systems. We've got new underwater vehicles that are checking pipelines to ensure both no emissions from those pipelines, but also to check the sea life that's formed around them. Has it actually, these pipelines actually become an artificial reef? All of this will better inform both the development of new law and policy, but also check for compliance. And then at the very extreme end, there's always some people and some situations which are breaking the law, in which case, can we use this type of technology for enforcement? Can we use it to gather evidence? Do our evidence laws allow us to use some of these new technologies in court to prosecute? These are some of the issues that I think are important for lawyers, maybe tangential to the central role of international environmental law, but certainly very important in terms of evidence and enforcement of the law.
But quite a strong intersection I'm hearing between such diverse fields of law. So we've got space law, you mentioned, we've got technology law and evidence law even, yeah.
So I think, and data is another big area, of course, data processing, big data, and again, how we interpret data. You and I could not read the image that we get from a satellite. It's like reading an X-ray. You need an intervening analysis. So we've got to make sure that our laws are up to the task. Our basic tools that we use in litigation are up to the task, but the basic also government in terms of its role in monitoring and managing often remote marine environments. There's a lot of this technology which will be very useful. And in that context, I was very happy that UWA Law School did establish a new elective unit in space and satellite law. So that's the first unit of its type in Western Australia, and I think it's really important for future lawyers to explore that area, as it is big data and other areas as well.
Absolutely. Well, look, Erika, I reckon that's been a very thoughtful discussion. Thanks so much for sharing some very learned insight and obviously raised some concepts and issues which are on the, I guess we're on the frontier of addressing and really quite I guess it'd be a role for us as university students, myself, to really start thinking about these things quite seriously. And so you've left me for a bit to think about at least. So,
well, international environmental law will be offered in January as a summer unit. All those people that are
Good little plug there. Thank you for that. Well, look, it's been a pleasure having you on, Erika. Thanks for taking the time, and thanks very much for your contribution to our journal in Volume 4.
Okay, thank you so much. I really enjoyed it.
Glad. Thank you.